Good morning. On behalf of the Department of Justice and some noise, the Stanford Graduate School of Business and the Rock Center for Corporate Governance, I want to welcome you to the Paul Brest Hall and Stanford University. I am Makan Delrahim. I have the privilege of serving as the Assistant Attorney General for Antitrust at the Department of Justice. Today's event is part of our ongoing effort at the department to understand the competitive conditions under which online platforms operate. I'm thrilled to have Stanford as a partner in this inquiry. By virtue of its brilliant faculty and location in the heart of Silicon Valley, I can think of no better institution to engage with us in understanding the intersection of entrepreneurship, investment, and competition policy. Stanford has provided thought leadership, has organized this lovely venue, and has made sure that our panels today will explore the most vital questions about how venture capital is working to spur innovation and competition. Without Stanford's critical contribution, this workshop would not have been possible, and its incredible faculty, including a number of our friends and alum from the Justice Department, Professor Doug Melamed, Professor Mark Lemley, Professor Grunfest, and a number of others. It's a real privilege to be here and be in partnership with Stanford. I also want to recognize the incredible work in partnership with Stanford that a number of my colleagues in the Antitrust Division have engaged in. The team was led capably by my counsel in the front office, Taylor Owings, and our Chief of Competition Policy, David Lawrence, and the project was really helmed by our talented competition policy attorney, Karina LaBelle. You'll get a chance to meet all of them as moderators on our panel later today. I also want to thank and recognize Associate Deputy Attorney General Ryan Shores, who's moderating one of our panels today and leading our investigations in this area. There's many others on our staff, both in the San Francisco office and around the division, who turned this workshop into a reality. And as you guys could imagine, at this great institution, it really is a privilege to go into work every day with a group of incredibly talented, gifted, and motivated people to call as your colleagues. And it's a real treat for me to say that. The author, Charles Duhigg, once wrote that, quote, "Between calculated risk and reckless decision-making lies a dividing line between profit and loss." This is an ethos that venture capitalists know well. So must antitrust enforcers. We both care deeply about market conditions that encourage entrepreneurs to take calculated risks that benefit society. This sort of risk-taking is part of the success story for any American business. This is also part of our national identity. It's no surprise that market-changing innovations in molecular biology and information technology alike are coming from the United States and coming particularly from the Valley here. One of our shared goals today, I think, is making sure that the balance between risk and work, and hard work and reward, upon which our thriving market economy has been based, remains strong. Another characteristic antitrust enforcers and venture capitalists have in common: we both spend a lot of time thinking about what might happen to business in the future. As the Supreme Court put it, our reviews of mergers, quote, "require a prediction of a merger's impact on competition, present and future," end quote. We measure harm based on how the market might respond to a merger or to a course of conduct. This is not guesswork. Neither is venture capital investment. Instead, we both look at the market draw from economics, and make educated predictions to the best of our capabilities. The antitrust laws also forbid unreasonable restraints of trade. How do you know if a restraint is unreasonable? In most cases, you have to think about how it affects firms' motivation and ability to compete. Then you need to measure the potential upsides against the possible downsides. This is similar to how a number of you in the venture capital community might evaluate an investment. What is the risk? What is the reward? Are we striking the right balance? Moreover, the antitrust laws prohibit firms from using exclusionary conduct to achieve or maintain monopoly power. In painting a picture of monopoly power, antitrust enforcers predict how diminished competition will result in the monopolist raising prices or reducing quality. Of course, a common argument by defendants in antitrust cases is that the future of the market will not allow them to exercise the monopoly power. Instead, they argue that disruptive innovation is just around the corner. It's an argument we have heard over the past 100 years. To address these arguments, antitrust enforcers often have to think hard about where innovation will really come from, or whether it will come at all. That means thinking a bit like venture capitalists to assess whether a new platform or startup will actually be able to challenge those in power today. In any case, whether a merger is harmful, a restraint is unreasonable, or a course of conduct is exclusionary, antitrust enforcers have to ask the same question. What do we do about it? In looking at that, we focus on trying to restore competition in the market going forward. That often involves asking what new competitors need to thrive in a constantly changing marketplace. It's a difficult challenge, but one familiar to many investors who support early-stage companies. Not only do venture capitalists and antitrust enforcers often ask similar questions, I think we share similar values. Dynamic competition should drive markets. Investment should go to the best ideas. Disruption can create consumer value. These are the principles I've continually returned to in both my 10 years at the Justice Department, most recently as the Assistant Attorney General. I first outlined these principles in the new Madison approach to the intersection of antitrust enforcement and intellectual property rights. They're also part of venture capital's DNA. I also think we share similar goals. Venture capital is a critical part of healthy competition according to antitrust theory and policy because it makes monopoly prices unsustainable. After all, where a monopolist gains the ability to charge a higher price, a venture-backed startup finds an opportunity to take hold and share in those rents. The health of venture capital and its promise of disciplining competition is therefore vital for American consumers and competition. Venture capital, as most in this room know, also drives our innovation economy. It ensures that a good idea leads to an even better mousetrap. Incentivizing and rewarding this type of innovation is essential to spurring competition and disrupting monopolies because even a single bet can uproot an entire industry. Antitrust enforcers and venture capitalists both depend on making sure that these types of bets in good ideas and in good entrepreneurs are encouraged and rewarded. Of course, the ability to take advantage of investment, such as through better innovation or development of intellectual property, is the essence of a strong market economy. And that result is not frowned upon by the antitrust laws. To take one such example that I find fascinating, Slack is a company that invented a better solution to an office communications problem, despite Microsoft's leading role in that space. Before its official launch to the public in February 2014, Slack faced a fragmented market in enterprise collaboration. But the market was one in which many giants competed. At the time, Microsoft, IBM, and Cisco each had a version of an Office, quote, social network. There was no clear front runner in the market, but Slack nevertheless encountered daunting odds. Financial analysts observed that Microsoft's Yammer, which functioned similarly to Slack in many respects, was, quote, growing strongly in the nascent enterprise social market net segment, experiencing year-on-year growth of 34%. Yet through its integration with other useful programs and its accessible interface, Slack grew astronomically in daily active users from 0 to over 8 million within 5 years. It did much better than many others in solving problems with team communications, showcasing how an entrant can gain footing in a market otherwise dominated by experienced firms. Notably, Slack would not exist but for the faith of the venture capitalists in that product, and most importantly, in the people who make them. For this reason, the origin story of Slack is captivating. Stuart Butterfield, the founder of Slack, had once been the CEO of a company called TinySpec. He spent 2 years and raised $11 million to build an online adventure group. But by 2012, it was clear the game was a failure. Butterfield made plans to shutter the company and return the money to investors. Yet Andrew Brescia, a partner at the venture capital firm Axel, refused to accept the refund. Along with a few others, he encouraged Butterfield to keep the remaining $5 million and try something new. That something new was Slack, which went public in June 2019 with a value of $19 billion at closing. Of course, one of the questions for our panelists here today is whether the success of Slack is an anomaly at odds with trends in the venture capital market. Slack's ability to IPO and provide an independent source of competition to other technology platforms is an example of a venture capital system working to create a healthy economy. There's some evidence we will hear about later in the day that these IPOs are increasingly rare. We as antitrust enforcers need to understand this evidence and if there are any causal explanations at odds with the antitrust laws. The decision to continue to invest was, I presume, due largely to Mr. Brescia's faith in Mr. Butterfield. As he later explained, quote, the reason we invested in TinySpec was because we were investing in the team. I told Stuart, quote, if you want to continue to be an entrepreneur and build something, then I'm with you, close quote. Why this determination? Perhaps because venture capitalists understood the wisdom once observed by Brooks Atkinson, Pulitzer Prize-winning American theater critic. Quote, he said, this nation was built by men who took risks, pioneers who were not afraid of the wilderness, businessmen who were not afraid of failure, scientists who were not afraid of the truth, thinkers who were not afraid of progress, dreamers who were not afraid of action, end quote. As many of you know, I came to this country as an immigrant. My parents were the ultimate entrepreneurs. They risked everything for a better life for me and my 2 siblings. They picked America, as many other generations have and will hopefully continue to do so. That's because among many other freedoms we're guaranteed in this country, our system of free markets provides the most promising returns on investments in hard work, education, and creative thinking. Our market economy, when it is free from unnecessary regulations by the government and free from illegal monopoly restraints by private actors, provides a risk-return rate that is the key to prosperity and dynamism. I know this resonates with many in this room, and frankly, probably many in Silicon Valley. As we engage in our discussions today, I'm hoping to learn answers to several questions. First, what does the venture capital community know about the likelihood of future disruptive innovation that could challenge today's technology giants? Second, are any of today's digital platforms so dominant with such a capability to restrict access to inputs or to distribution of products that investors are not willing to develop products that rely on those platforms? Third, Where are we in the life cycle of the market for data about how people interact with websites and with their phones or wearables? We're engaged in a national debate about the value of keeping that information private, but do we have a sense of what that information might be worth in different markets and how consumers may be served by rules that allow the collection and use of that data? Fourth, what tools does the venture capital community use to evaluate the strategic value of a transaction that we as antitrust enforcers can utilize to think about whether a transaction is premised on creating value for consumers versus preventing competition? Before I turn the podium to our first panel of the day, I want to encourage all of you to take note of the email address we have set up for this event, which is posted on the slides up here, atr.vcworkshop@usdoj.gov. We hope that today's discussion will be so dynamic that you'll want to get involved by emailing any thoughts or maybe even your concerns about anti-competitive conduct that you have witnessed to our DOJ email account. You are, of course, welcome to request anonymity and confidentiality. It'll be our DOJ staff receiving these emails only. We will also be using this email throughout the day to keep track of audience questions. Each panel's moderator will draw from the inbox to pose audience questions to their panelists. So feel free to have your phones out during this discussion and use the email address to ask your most burning questions to our excellent panelists. With that, please welcome the W.A. Frank Professor of Law and Business, Dr. Joe Grunfest. Dr. Grunfest will introduce our first distinguished guest from the venture capital community, and I want to thank each of the panelists for their participation today, for taking the time to contribute to this important discussion as we all try to better understand the competitive forces here. Joe?